All right, we are back on the record in the state of Florida versus William Woodward, case number 2012 CF 55504A. I'll note the presence of Mr. Woodward at council table with Mr. Robinson and Mr. Eisenmenger, and the presence of Mr. Respis and Mr. Shiner on behalf of the state. So, Mr. Eisenmenger, you had indicated that was the end of the presentation of the defense. Is there anything else you'd like to add?
No additional evidence. I do want to go back briefly and address the issue of the pre-sentence investigation. Family history, marital history, military history, physical and mental health of the defendant, and residential history are all required by statute as part of a pre-sentence investigation, none of which were done by probation and parole in this case, under the mistaken belief that because my client exercised his right not to be interviewed, that somehow removed their obligation to comply with the statute. We have undertaken, as part of our presentation of evidence, so as not to delay the sentencing, some testimony through his mother as to those issues. If there's any issue about the inadequacy of the record that we've taken upon ourselves to put in the record so not to delay sentencing, then I would like to know now. And if there is, then we would request a continuance of the sentencing and an order for probation and parole to fulfill their statutory responsibilities. If the court is satisfied and the state is satisfied with the information that we've supplemented the pre-sentence investigation with its sentencing, then it would not be necessary to do so.
State have any input?
Well, if this was going to be an issue, I wish we'd had discussed it for today, because this PSI has been around since March, I guess March 20th, or it was e-filed on March 27th, and we could have gotten this accomplished before dealing with it now. I'm not in a position to quarrel with anything. Many of the things that would be in here came out in the trial because the crime happened in the defendant's neighborhood and his house was involved in it, and the family situation was involved in it. I think the only thing we didn't learn was about his brother. Most of his family testified.
Well, you know, I don't mean to interrupt you, Mr. Respis, but I'm looking at the pre-sentence investigation, and the bottom of page 4 is the first section that appears to be blank, if you will, because of the notes indicating that an interview was rejected by the defendant. His education,
Right.
do you agree that the record's been supplemented satisfactorily by the testimony of Mr. Woodward's mother?
I think it was his father that supplemented hers, so I guess between the two of them.
Okay, well, I just want to make sure that the state is satisfied, and if the defense is indicating that if the state or the court are not satisfied, then maybe we need to reschedule and have this completed.
I don't want to reschedule this.
I understand that you may not wish to reschedule it, so I'm asking, as Mr. Eisenmenger has presented, is there any dispute of the supplemental testimony that can, in essence, supplement this pre-sentence investigation? So it's based on the education history, the employment summary, financial status, family history, marital history, military history, physical and mental health, residential history, alcohol, substance abuse, and the defendant's plan. I'm not sure who they would seek out to find out what the defendant's plan, but
That's not actually required by statute. And again, the alcohol substance abuse is actually optional, but we did address it. What is required by statute is family history, marital history, military history, physical and mental health, and residential history. And quite honestly, this got filed when it was e-filed in my file, and I did not review it until just a couple of days ago. I did have a conversation with probation where they had contacted me and demanded an interview with my client, and I explained to them that on my advice, we were not doing that. And that also failed to make a pre-sentence investigation. But more importantly, I was rather shocked when I read this, that they were bypassing their statutory obligation by trying to create an obligation by my client to be interviewed, which is not only contrary to his constitutional rights, but contrary to statute. There's nothing in the statute that says this information has to come from an interview with the defendant. There's various different ways to verify this. They didn't do anything, and they're required to do it. And again, when I discovered it, I decided that I would just address it through witnesses, but I don't want there to be a claim down the road at some point in time that there was some dispute or some inadequacy of material that the state, not the state attorney, but the state of Florida through probation and parole was required to do and did not do.
Well, the evidence in this case covers these issues. There's conflict in it. I mean, the defendant told Ms. King, was it Ms. Max Caskey, that he left employment as a result of that he threatened to kill his supervisor. His father contests that assertion. So, I mean, there's a dispute in the record. The mother didn't know when he left work, but we're satisfied that the court has a flavor of how his employment situation. There's no dispute that he was receiving benefits from the VA or veterans benefits when this incident happened, and that was how they were, that along with his wife's income, that was how they were surviving. So, we think there's enough information for the court to make this decision. It's not in the pre-sentence investigation.
And I assume that also goes that there's no dispute that he was disabled at the time of this incident. Because
That's
physical
correct.
and mental health is a required section.
We received the information from the VA. I think we've had examination and cross-examination on some of the VA records. I'm happy to put those into the record if the court and counsel want them, so that's there.
Well, I want to ensure that both parties are satisfied with the pre-sentence investigation and the supplement to the record with the additional testimony that was presented by Mr. Eisenmenger through the witnesses and the family members on those areas that are, in essence, left blank in the pre-sentence investigation. So is the state satisfied with the supplement of the record?
Yes, everything's not in there, but I'm satisfied.
All right, and the defense is not asking for any further relief. You're not asking to continue this any further for the Department of Corrections to, in essence, fill in those gaps?
Not without representation by the state. Based on the representation of the state, they're satisfied, hence the issue for them.
All right, thank you. The court is satisfied as well and has obviously received additional supplemental testimony to supplement those responses and information that are otherwise included in the pre-sentence investigation. So, Mr. Eisenmenger, with that, are you resting at this time as far as any evidence or additional?
Presentation of evidence, I just have case law and argument to make to the court.
Okay, and would you like to argue first?
However the court wants. If I may approach, I have some case law.
You may.
Sent to the court. I'm giving copies to counsel.
Okay, thank you. All right, the defense's argument in regards to the sentence?
Judge, there are several statutory and non-statutory mitigating factors. I believe that the evidence throughout the trial and including presentation today has established. First and foremost, I believe the evidence is overwhelming that the victims in this case were the initiators of the violence in this situation, that their harassment was ongoing for a significant period of time, that they subjected the defendant to extreme duress, that the defendant at the time that he was being subjected to this had essentially a diminished capacity by virtue of his mental and physical health as a result of his brain injury and his PTSD. more importantly, the evidence is overwhelming that not only were the alleged victims in this case, or the deceased and the injured individual in this case, aware of it, that it was a focus of their activities directed specifically against Mr. Woodward and generally against his family and any neighbor who did not support them in this action. The evidence. Now, part of the issue in this case, obviously it was a defense of self-defense, and one of the issues comes is that despite the fact that the jury, by virtue of their verdict guilty of second-degree murder, rejected the justifiable use of force, whether or not the court can still rely on victim provocation and the actions of the victim as a downward departure. And I cited to the court and provided a copy, State of Ty Van Lee at 553 Southern 2nd, 258. It's a Second District Court of Appeals 1989 case. It is still good law. The only negative treatment, as is noted in that, was the State v. Ember, which did not extend that to a situation involving grand theft. The facts of Ember had little or nothing to do with victim provocation. And so in terms of victim provocation, this is still good law in the state of the law itself. And so what the finding of the Second District Court of Appeals essentially is even though a self-defense claim may have not been sufficient to be a complete defense in the eyes of the jury, it still can provide a mitigating factor which the court can rely upon for a downward departure. And certainly if there was any case that indicated a factual pattern of extreme provocation by the alleged victims in this case, it would be this one. There is also the issue of whether or not Mr. Woodward requires specialized treatment and whether or not he is amenable to treatment. There are two cases that I cited to the court. The Chubbuck case, 83 Southern 3rd, 918, which is a 4th District Court of Appeals case in 2012, and the Mitchell case, cited at 147 Southern 3rd, 93, which is a 2nd District Court of Appeals case following Chubbuck and basically reaffirming the ruling in Chubbuck. And that is essentially to warrant a downward departure, the defendant had to merely prove by a preponderance of the evidence that he had a physical disability or a mental disorder that was unrelated to substance abuse or addiction, and that he needed specialized treatment and he was amenable to that treatment. Both the testimony during the trial itself about his disability, the fact that the state had indicated that the supplemental information, that there was no dispute about his disability, the testimony of Dr. Mings today, that both his physical disability, which has manifested itself in organic mental injury, and his PTSD not only requires specialized treatment, but the defendant had been participating in specialized treatment by the VA for a number of years, establishes both the need for specialized treatment and that he is amenable to it. Both the Mitchell and the Chubbuck courts retreated from the requirements of previous case law, had said that it required a defendant to establish that he required specialized treatment, which was unavailable in the DOC. Both Chubbuck and Mitchell stand for the proposition that it's not the defendant's burden, it would be the state's burden by those cases to prove that the specialized treatment was available in DOC. There has been no showing of that in this particular case. So the mitigating factor has been fully proven and not disputed by any evidence by the state. I've cited the Cazell case, which is 42 Southern 3rd 252, more for the general proposition that a court's decision whether to depart from the guidelines is a two-part process whereby the court must first determine whether it can depart and then decide whether it should depart. We believe that the evidence is overwhelming in this situation, that there are mitigating factors that would allow, we only really have to establish one, but there are multiple in this case. There's also non-statutory mitigating factors in this particular case. The evidence supports that as a result of this, he's going to suffer the collateral punishment of loss of his VA benefits as a result of this conviction. There was testimony during trial of that. There's more testimony today regarding that. That's an additional punishment that applies to Mr. Woodward that is not contemplated by statute, that really only applies to disabled veterans. And we would like the court to consider that as a non-statutory mitigating factor. We also have the statutory mitigating factor that his capacity to appreciate the criminality of this conduct and conform his activities to the constraints of law was substantially impaired. Again, we believe that both the testimony at trial, the testimony of Dr. Mings today, the testimony that really came out of his medical records of the VA itself, that the most recent visit just before this incident pretty much defines Mr. Woodward's state of mind and ability as affected by his disabilities to conform his activities. It shows the struggle that he was having given the provocation of his neighbors, his fears for his family, the fact that he felt that he could control his activities as long as his family's safety was not compromised. It is, of course, our position that his actions in this particular case were prompted by concerns for his family and that he was acting what he believed was genuine issues regarding the safety of his family and reacted to that. The jury's rejection of first-degree murder in theory and acceptance of the second-degree murder makes these sentencing arguments even more relevant because we have a situation where the jury has rejected any notion that this was premeditated. They have rejected any notion that it was under any theory other than a crime of second-degree murder is quite often referred to a crime of passion and a crime of response without any conscious intent to kill. So all of those theories have been considered and rejected by the jury in returning a verdict to second-degree murder. And therefore, the factor of victim provocation becomes even more significant in this type of situation. The Hines case, which is cited at 817 Southern 2nd 964, likewise deals with this issue. And it's a Second District Court of Appeals case as well. It holds that a downward departure sentence can be imposed even though a jury rejected a self-defense claim. In this particular case, the court felt like it could not use that as a mitigating factor, and it was remanded for sentencing because the law is contrary to the court's mistaken belief in the Hines case that the jury verdict would prohibit. Instead, the courts have held significantly in a couple of different cases, but specifically in Hines, that the downward departure based on the alleged victim's conduct as an initiator, willing participant, and aggressor or provoker of the incident, as listed in 921-00164F Florida statute, is a statutory allowed mitigating factor that can be used as a basis for downward departure. Based on the issue, there is a mitigating factor that I think deserves some consideration and may not be fully developed in this case because of the issue of remorse. And we have a situation, well, definitely there's evidence in the record, testimony of Mr. Woodward, that he regrets that the incident happened and wished that it could have been resolved a different way. His belief that he was justified in his actions came throughout that. The question is whether that is not indicative of remorse. And I would suggest to the court that it is not. It is rather indicative, if you look at the totality of his behavior in this particular case, it is indicative of a person who tried to resolve these issues in every other way. Mr. Woodward went out of his way to report these actions to the police and seek police protection for himself and his family and his neighbors. Other neighbors went out of their way to report this conduct to the police. And the police were not able to provide any action. Mr. Woodward sought injunctive relief through the courts. And because he did not ask for the right type of release, asked for essentially repeat violence relief, instead of asking for injunctive release based on stalking or aggravated stalking, he was denied that relief. So Mr. Woodward was essentially left on an island where he felt that he had no option other than to protect his family. It is still our position that Mr. Woodward waited and acted only until he felt that action by the deceased was imminent, though we do not believe that that is a requirement. And of course, that's one of our motions for new trial and potential points on appeal as to whether or not that requirement is present when you have an aggravated stalking. But the fact that Mr. Woodward felt that his actions were justified does not change the fact that he tried to avoid any other action and consistently had indicated throughout his discussions, both to his treater, to law enforcement, to other people, such as his friend, school friend who testified, that it was a last resort. Avoid that. Do the right thing. Report it. Get the people involved. That was his focus. And I do not think that that is incompatible with remorse. I think it's indicative of remorse. And so therefore, I'm asking the court to also consider that this was done in an unsophisticated manner and was an isolated incident. I also recognize that the state may argue that it's not an isolated incident because of what happened at the courthouse. But I would suggest to the court that that is a continuing course of events, prompted and provoked, according to the testimony, by the alleged victims in this particular case. So that does not change the isolated nature of this. Certainly, Mr. Woodward has never had any problem with the law in any way, shape, or form that was not directed toward the initial provokers and aggressors of this particular incident. So we are asking the court to sentence Mr. Woodward to 25 years, mandatory minimum, because it's required. You have, I agree that you have no discretion under the statute in terms of this. Where you do have discretion is whether or not to run those sentences consecutive or concurrently. We're asking you to run them concurrently. We're asking you to find one or more of the mitigating factors for downward departure so that the court does not need to impose the approximately 45-year sentence that is at the low end of the guidelines. And it is our strongly held position that that is a sentence that, quite honestly, under the circumstances of this case, is harsher than it needs to be. And it certainly is a situation that, had the court had more discretion, we would be asking for a greater exercise in the court's discretion. I also want to put on the record, because it may come back in some way, shape, or form, Mr. Woodward had indicated to counsel a desire to address the court on the remorse issue, and it was my advice, and based on my advice, that Mr. Woodward did not make a statement today because of the appellate issues going forward, and our hopes and beliefs that he will receive a new trial, and likewise did not make a statement during pre-sentence investigation. So that was 100% a decision by counsel that Mr. Woodward acquiesced to.
All right, before I hear from the state, just so I'm very clear, Mr. Eiseminger, on the factors that you're asking me to find mitigating circumstances pursuant to 921.0026, you are arguing 2C, 2D, 2F, 2J. Did I miss any others other than the non-statutory loss of the
I apologize,
benefits?
I don't know them by number.
Okay.
So I would have to state them. The statutory factors that the alleged victims were initiators, aggressors, or provokers of the offense.
Okay, that's F.
That Mr. Woodward's capacity to appreciate the criminality of his conduct and conform his conduct to the constraints of society.
That's C, thank you.
The need, the existence of two conditions that need specialized treatment and his amenability to specialized treatment.
Okay, that's D.
That he acted under extreme duress. That duress was directed toward him by the alleged victims in this case.
All right, that's G. I didn't state that earlier, but I will note that. And then the
non-statutory factor of the collateral consequences of the VA actions and loss of disability benefits and VA benefits as a result of this conviction.
I think you also were arguing that the offense was committed in an unsophisticated manner.
Yes, I did.
Okay, and that is
I
J.
argued that it was done in an unsophisticated manner, it was an isolated incident, and that the defendant's actions and the way he conducted himself demonstrates sufficient remorse for that mitigating factor.
Okay, thank you. State's argument?
Well, let me start with where we agree, and then we'll deal with the other side. My understanding of the law is a little different than Mr. Eiseminger's on what they're required to prove on D, 921.0026D. And I'm basing that on State versus Owens, which is a 5th District case, 95 Southern 3rd, 1018. And I think that case says that the defense, the state, it doesn't matter. Neither side needs to show anything about whether or not treatment's available in prison, because that's not included in the legislation, and the court should not put extra requirements in legislation that's not there. I think that's me summing up what Owen says, but frankly, what has to be shown is what's in the statute, which is that he requires specialized treatment for a mental disorder. It's not related to substance abuse or addiction. and the defendant is amenable to treatment. And we're not disputing that he's shown amenability because he was being treated right up until this happened, and that the issue, that he had the issue before. We're questioning whether or not it's appropriate under the circumstances to use that as a basis to downward depart, but that departure ground, I believe, is present. The suggestion of the other mental mitigator, I would suggest, was not shown. That's, I've got State versus Milici. It's another 5th District case, 219 Southern 3rd 117. Now here, the doctor has conceded that the defendant recognized the consequences. He was talking about the consequences a short time before, with his doctor, a short time before the crime happened. And there's no evidence, and the doctor repeatedly said, I can only say this in general terms. There was no evidence that he could not conform his conduct to the requirements of the law. And you have to have competent evidence that supports the finding. That's on Head Note 10, which is page 6 in the way I provided it to you. And this talks about Malachi presented no expert testimony to establish that his alleged mental health issues prevented him from appreciating the nature of his criminal nature of his actions. Here, they presented no evidence about how his mental health issues prevented him from conforming his conduct to the requirements of law. And you take that along with the facts we have in this case, because while the jury didn't find him guilty of first-degree murder, what they did find is that he committed a crime with malice aforethought, that he committed an action that he should have known could kill people, which going over and shooting them multiple times would be that. And we have to look at the facts and circumstances that he was faced with, because this is not an impulsive act, Your Honor. The evidence is undisputed, because we have it on a videotape, that the defendant was sitting out there for more than 20 minutes, and that no provocation was going on at the time he did this, which is one of the reasons I'm confident that the jury rejected justifiable use of force in this case. So there's no factual support for that he had an inability to conform his conduct to the requirements of law. What we have here, and what the evidence has shown throughout, when you take out the square peg and the round hole justification, where the efforts to justify, this whole case started off as a mental health case. And it was a mental health case that did not fit into insanity. And that's what the defendant talked about. And Judge Earp found that credible. I'm suggesting the jury found that credible, and I'm asking you to find it credible, that his statements about why he did these things was he was out there and he snapped. Well, he snapped and made a bunch of decisions to do these things, but he knew what he was doing. He knew it was wrong. His behavior after he did it is consistent with his knowledge that it's wrong, when he drops his firearm and puts his hands over his head and allows himself to be cuffed. So there's nothing about this case that shows that particular downward departure ground would be present, and I would suggest the court should reject that. The next question, and I guess if we're dealing with the night the incident happened, then the court could find the victims were the initiators because they were the ones out there running their mouths about come out and fight and showing their behinds and doing the things that are on that the state never contested because it was bad behavior. And so if that's the type of initiation that justifies someone going out and killing, then I would suggest that might mitigate. The case they're citing is when genuine self-defense is at issue. And I would suggest this is taunting to make someone mad, which they succeeded in doing, and he reacted to being angry. I don't believe that's the type of initiator, provoker, that someone says, okay, the court should consider mitigation. If we go back to the whole picture, this whole incident starts with the defendant getting into it with Mr. Hembry. And it was about the chickens because Mr. Hembry reacted to him accusing his daughter by going and taking a picture of some chickens, and here we go. He gets angry about that, and he initiates and wants to fight. There was two people, there was testimony by Kim Salisbury about what happened at the courthouse. And if that's believed, and it's entirely consistent with what happened, the defendant, who was angry that the court didn't give him what he wanted, took it out on Mr. Hembry. Nothing more. And Ms. Salisbury was dealing with the issues that she was scared and had gone into the bathroom, and that's why they were there. And the defendant felt because they were still there, he needed to attack them. So I don't believe that the court should accept that as a mitigator in this circumstance. The defendant was under the domination of no one else, so I don't see how G can apply. He may have been under duress. We can debate whether or not he was under extreme duress, but he wasn't under the domination of anyone. He was his reasons for being there were of anger because these folks had treated him and his family this way, and he wanted to get even. The last statutory mitigator that I heard was the offense was committed in an unsophisticated manner. I would suggest that there was nothing unsophisticated about this. The defendant waited until his family went to sleep, or he thought they were asleep, armed himself, lay in wait, and waited until the situation was appropriate for him to launch his attack. Now, he went over there and shot him multiple times. The jury didn't find premeditated intent, so they found that he went over there with evil intent to shoot people multiple times, and 2 people died and 1 didn't. But that is not, it's not unsophisticated. It's not isolated because by my count, the defendant had been arrested. That was the 3rd arrest for the defendant related to these parties. The first arrest involved the firearm that was ultimately charged as an obstruction or I think a disorderly conduct. The second arrest was the event at the courthouse, and the third arrest is when he killed 3 people, or killed 2 people and almost killed a third. And I would suggest there's no evidence of remorse in this case. The last downward departure ground that I believe is there's some evidence that there's a suggestion there's some evidence about VA benefits. And I would suggest there's no evidence that's been presented here meaningfully about the consequences of the crime. The defendant, in his statement to the detective, talked about the consequences and that potentially being one of them, along with not being able to go forward with the house purchase and a number of other things. I would suggest that that is not the type of evidence that would be sufficient where the court can make findings one way or the other about that. I don't think there's evidence one way or the other about that, and so I would suggest that you reject that. Now, the state's position is that what we're punishing Mr. Woodward for is his vigilantism, his perceived decision to enforce his own laws as it relates to these victims. Because essentially he gave them a death sentence or severe injury as a result of committing misdemeanor stalking against him on the evening that this happened. And that's by repeatedly coming up and baiting them to fight or showing their behinds or doing things that were harassment. And the case is not an impulsive one. We now know that he'd been thinking about seriously hurting or killing these people for weeks. For weeks he'd been thinking about this. And we also know that he was planning on moving. His statement to the police was he's planning on beginning moving the next day. So this was a crime that happened because he was angry at the way his family, he perceived his family had been treated, the way he'd been treated, and this was his way to punish them for those acts. And that's why he did what he did. This was not about fear. This was not about threat of immediate harm. It was none of those things. And this morphed into this when mental health was not going to be a defense in this case. So the question the court has is, what does the legislature say the primary purpose of sentencing is? And the primary purpose of sentencing is punishment. So how do we punish someone that's killed one person? How do we punish someone that almost killed another person? How do we punish someone that actually killed the third person injured in this, shot in this? And my suggestion is that how do we let that person out into society when he's demonstrated those types of anger control issues anyways? I mean, he was getting help. And he had rationalized. And he still convinced himself that this was the right thing to do, that he can go, that there was his own personal war that had been declared, and he had the right to treat them as combatants on a battlefield and execute them. Because that's what he told the law enforcement from the beginning, and that's what he did. The state's suggestion is that the appropriate sentence is life. And how you structure that, you can give him 3 consecutive 25-year sentences, and that should do it. You can give him a life sentence and everything concurrent, and that will do it. But if you're going to give him less than that, I encourage you to put him on supervision for the rest of his life, and that whatever probation conditions you have, that it includes mental health treatment and counseling if he ever does get out. Because I perceive that if he gets out and someone makes him angry and he doesn't like the way he feels he's being treated, because it's almost interesting listening to his father as he's making excuses for his son. The defendant seems to have problems interacting with people and getting into situations where there's a perception that he is being bullied. And then he gets angry as a result of that. And then ultimately we end up in court here where no one wants to be, and everyone feels horrible because his family's punished with him, these survivors are punished, and we are left as a judicial system to pick up the pieces. So I ask you to reflect on those things and reflect on the appropriate sentence in the case. And again, we would recommend that you sentence him to a life sentence. Thank you.
Actually, just very briefly, by the way.
You may.
Statutory mitigating factor is extreme duress or under the substantial domination of another. We do not suggest that the second prong of that exists in this case, but it's not necessary to have both for that statutory mitigator. There's certainly evidence of extreme duress. There's also, essentially, Black's Law Dictionary defines an aggressor as a person by his or her wrongful act provokes, brings about, or continues an altercation. A provoker is one who engages in conduct or actions toward another as tend to arouse rage, resentment, or fury in the latter against the former, thereby causing the latter to do some illegal act against or in retaliation to the person offering the provocation. That is the state's position of what they think happened. And yet they're denying the alleged victim's role as the provoker. They sat there and told the court that it is their theory of the case that Mr. Woodward felt provoked by the actions not only that night, but prior to that night. And in their view, did some illegal act in retaliation against the provoker. Well, that's exactly what the definition of a provoker is, and the fact that the victim is the provoker is a statutory mitigating factor. Now, admittedly, it is not our position that he acted in retaliation. It is our position that he acted in self-defense. But that's not necessary to the mitigating factor one way or another of whether or not the alleged victim was the provoker. By definition, the alleged victims in this case were provokers. And not only, it's always fascinating to me that the state conveniently leaves out the most significant provocative threats. Burning somebody's house while they slept, having their daughter kidnapped and anally raped, threats that were repeated by multiple people in this group, and then the actions of burning something while making threats toward him that night before he acted. All of those qualify as not only aggressive acts, but provocation, both of which qualify as a mitigating factor.
All right, thank you all. Does either party have any time constraint in terms of the court taking a brief recess?
No. We'd rather get it done.
Okay. All right, I'm going to take a brief recess. I'll be back with you all in just a few moments in regards to the sentence. We'll be in recess. I'll be back as soon as possible. Thank you. We are back on the record in the state of Florida versus William Woodward, case number 2012 CF 55504A. I will note the presence of Mr. Woodward at council table with Mr. Eiseminger and Mr. Robinson, and the presence of Mr. Respis and Mr. Shiner on behalf of the state. Thank you all for your patience. I did review the case law and reviewed my notes from the evidence and testimony and various letters that were submitted in evidence, and I will make the following findings at this time. The defense requested downward departures specifically pursuant to 921.0026, subparagraph 2. The first factor that they argued for downward departure was pursuant to subparagraph 2C. And before I make my findings as to each of those factors, I would also like to note for the record that the court, pursuant to State versus Chubbuck, which is one of the cases actually cited by the parties, 141 Southern 3rd, 1163. It's a Florida Supreme Court case from 2014. The court must follow a two-step analysis. First, the court must determine whether it can depart. Is there a valid legal ground and adequate factual support by a preponderance of the evidence for the ground, meaning was there competent substantial evidence sufficient shown by the defense to support that basis under 921.0026. Second, the court must determine whether it should depart. The court is required to weigh the totality of the circumstances, and that is within the sound discretion of the court. As to factor 2C, the capacity of the defendant to appreciate the criminal nature of the conduct or to conform that conduct to the requirements of law was substantially impaired. I do find that the burden of proof was not met by the defense. And even though Dr. Ming spoke with the defendant, he was simply evaluating competency issues. He did not discuss or talk to the defendant about what happened. And therefore, the court finds it would be difficult for Dr. Mings to be able to give an adequate opinion regarding the defendant's ability or impairment of conforming his conduct to societal laws and norms. Clearly, the defendant understood the consequences of his actions. As to 921.00262D, the defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction or for a physical disability, and the defendant is amenable to treatment. I do find that the burden of proof has been met by the defense, and I believe the state stipulated, so both state and defense agreed that that factor has been met, that the defendant does require specialized treatment for a mental disorder. It is unrelated to substance abuse, and he is amenable to treatment. As to 921.00262F, the victim was an initiator, willing participant, aggressor, or provoker of the incident. I do find that the burden of proof has been met, that the victims were provokers and did initiate some actions and conduct that clearly affected the defendant's ultimate actions in this case. Pursuant to 921.00262G, the defendant acted under extreme duress or under the domination of another person. It was only argued that he acted under extreme duress. I do find that the burden of proof has been met by the defense, and that the defendant over time was stressed due to the activities of the neighbors and may have been under duress when he decided to take action that night that resulted in us being involved in this case. Pursuant to 921.00262J, the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. I do find that the burden of proof has not been met as to that factor. The court finds that the defendant took specific steps that evening as the testimony and evidence presented at trial support. Specifically, he armed himself, went outside for more surveillance, then crawled across the street and fired 31 bullets at his neighbors. That is not an unsophisticated manner. As to the non-statutory basis for downward departure of the loss of the VA benefits for Mr. Woodward, the court finds that there was insufficient evidence to support this factor. So again, pursuant to the Chubbuck case, 141 Southern 3rd 1163, the court must still determine if it should depart. A downward departure is discretionary with the court, and in other words, is a downward departure the best sentencing option for the defendant? The court has weighed the totality of the circumstances in this case, having considered all of the testimony and evidence presented during the trial from January 17th through January 31st, when the jury reached its verdicts on all 3 counts. Even if the court found that the defense had met its burden of proof on all factors they argued in mitigation, the court finds that departure is not appropriate and is not the best sentencing option for Mr. Woodward. So I will impose sentence as follows. Before I do so, let me ask the state, obviously mandatory court costs apply, cost of prosecution. Are there any other costs that the state is seeking in this case?
Do we have I'd ask you to reserve for cost of investigation because I didn't bring that over.
Defense have any objection to the court reserving on the cost of investigation?
Find it owing.
I'm sorry?
Find it owing, reserve as to amount.
No, that's fine. I mean, we are going to be filing a notice of appeal tomorrow, so there may be some logistical problems with having a hearing, but that would be the only concern I have.
Where's the PSI?
So the state doesn't have any proof of any cost of investigation in this case?
Judge, I'm looking at that right now and hope to have it for the end.
Any other costs that the state is seeking?
I'd ask you to reserve as to the restitution amounts that I have are $7,981 to Jeannie Hubbard for the funeral. I don't have numbers for Mr. Kapoor or costs for Bruce Blake.
Okay, the restitution amount that you just mentioned, is that as noted in the pre-sentence investigation?
Yes, ma'am.
Because we didn't discuss restitution. Defense wish to be heard regarding the restitution issue?
The only restitution that was mentioned in the pre-sentence investigation, I haven't received any records to substantiate it or cost of the funeral. I would agree that that would be appropriate restitution. However, I don't have any verification as to the amounts. If they can provide me verifications of the amounts, we may be able to stipulate that.
Did you bring your receipts? We don't have it. We're going to ask you to reserve as to all 3.
Okay, so
Find it owing, reserve as to all 3.
so the state's asking me to order restitution but reserve as to the amount?
Yes, that would be on all 3 victims.
Defense wish to be heard regarding that request?
Again, the only caveat is that we may have some logistical problems if we lose jurisdiction to the appellate court. With that in mind, I have no objection.
Thank you. State have an answer yet on the cost of investigation?
No, Judge.
You were set for sentencing, so assuming the state was aware that that issue would come up, so you don't have any affidavit to support the cost of investigation?
We don't have it in imaging, so no.
All right, thank you. All right, based on the findings just noted on the record, the court imposes the following sentence as to count 1. And again, based on the jury verdicts that were rendered on January 31st, as to count 1, which is the verdict of guilty of second-degree murder with discharge of a firearm causing death as to victim Gary Hembry, I will adjudicate Mr. Woodward guilty of that charge and order him to serve life in prison. As to count 2, the jury verdict of guilty of second-degree murder with the discharge of a firearm causing death as to Roger P. Core, I will adjudicate Mr. Woodward guilty and order him to serve life in prison. As to count 3, the verdict of attempted second-degree murder with discharge of a firearm causing great bodily harm as to Bruce Timothy Blake, I will adjudicate Mr. Woodward guilty, and I will order him to serve the lowest permissible prison sentence as noted on the score sheet, which the court has accepted, of 543 months, which equates to 45.25 years. All of these will run concurrent. I will order a mandatory court cost of prosecution of $100. I will order restitution but reserve as to the amount. And I will also order costs of investigation if the state can present adequate evidence in the future but reserve as to the amount. And the defendant is entitled to original jail credit of 2,047 days in this case. Mr. Woodward, I'm also required to advise you of the right to appeal the judgment and sentence in this case within 30 days, and if you cannot afford to hire an attorney for the purpose of the appeal, one will be appointed for you. Is there anything else?
I have an affidavit of indigency. I prepared a motion, but because of the hour, we won't be able to electronically file it.
Okay.
But I will file it tomorrow morning, asking for the public defender to be appointed on appeal. Also concurrent with that, we will file the notice of appeal and statement of judicial acts to be reviewed and designation of the records, which are the trial attorney's obligations. So I'd ask the court to go ahead and appoint the public defender without the necessity of us having an additional hearing.
All right, state have any input on the appointment of the public defender for purpose of the appeal and the finding of indigency for Mr. Woodward?
We're not going to be involved in his counsel status.
Okay, thank you. So at this time, I will find that Mr. Woodward is indigent. I'll appoint the public defender for purposes of appeal. That is forthcoming. That will be filed tomorrow. And anything else the defense would like to address?
No, ma'am.
Anything further from the state?
I would like to address a couple of things. The first thing is I believe in each of the accounts there needs to be a 25-year minimum mandatory sentence.
So I need to note that on the record then?
I believe you do.
As to counts 1 and 2?
All three.
Okay, as discussed previously, I will also note for the record that there are minimum mandatory sentences of 25 years on counts 1, 2, and 3. I will note that and include it in my judgment and sentence.
Right. And I have concerns about the sentence on count 3 as being potentially illegal because in the same score sheet, you have sentencing to a guideline sentence or one that's in excess of 543 months, and the statutory maximum for count 3 is 30 years. I think that's the most you're going to be able to give them. Do you disagree?
No, I think it's an illegal sentence on count 3.
Right. I think if it was a situation where it was just count 3 and it was 543 months and you needed to do that to get it up there, that would become the new statutory maximum. But I think because he's been sentenced to in excess of 543 months on the other 2 counts, that you have to give him at most 30 years on count 3.
All right, well, I perhaps misunderstood the Smith versus State case, 93 Southern 3rd 387, that holds that when the lowest permissible sentence on a score sheet exceeds the statutory maximum, the lowest permissible prison sentence must be imposed, since I didn't find a downward departure.
Right.
So if the parties agree that that's an illegal sentence, I certainly don't want to impose an illegal sentence on as to count 3. So,
well, I think it's going to come back as a 3800 motion. Can I look at Smith and see what, just so I can take a quick look, because I think that Smith may be a situation where there was no count that was above.
I don't know that I have the actual case with me. It may,
Okay, can we pull that?
I mean, you can certainly pull it up. The Smith
Give us
versus
cite-
State case, which is 93 Southern 3rd, 387. And that's what I was following as to count 3.
Sorry, you said 90,
3 Southern 3rd, 387.